Good morning, everybody. Welcome to your reunion. We're so glad to have you back to Vanderbilt and glad that with such robust agendas and events planned for you that you're able to make your time this morning to join us. My name is Joe Teague. I'm the Assistant Vice Chancellor for Development and Alumni Relations for Vanderbilt University, and I'm pleased all of you are here. I've got a couple of housekeeping items before I turn it over to our speaker. I want to make sure all of you are aware of a couple of things. But number one, if you need to go to the restroom, it's out the door to your right, all the way back around. As you get towards the elevators, you'll see the sign. So be sure and just turn to your right. You'll be able to find it. Second, if you need more food and drink, or as you're leaving and you need a little snack for the road, take some. We have plenty left, and we'd love to have you take it with you. You have packets in front of you. We'll go over just a moment. I'll tell you what's in your packet. You have a comprehensive guide that Mr. Buckner has provided for you, which will be much of what you'll talk about today in much greater detail. We're not going to go line by line, and certainly not necessary, but it's a good guide for you to use as you're using it in your estate planning and as you're using it with your attorneys or your tax advisors. So please take that with you, and if you'd like other copies, you can certainly contact us and get those from us as well. The second is a little notebook or a little tab in there called a personal inventory guide. This is for you to use with your estate planning professionals to map out what are your assets and what you have. That's a complement of our university, and you can take that with you. And if you need an extra one, I will give you one note of caution. You might want to do it in pencil because circumstances change. You don't want to have to keep marking through it with that black mark slot over and over again so you can't read it, but do it in pencil. It's a good idea. Also in there's note paper for you to take notes, and then an evaluation form. And please fill out the evaluation form. For us to provide content that you as alumni would like to have, we want to make sure we're fitting your needs, and we can only do that if we know what your responses are to that. So please take some time. As you're leaving, you would hand it to one of the individuals standing by the door, and we'll make sure and use that to properly plan for next year. And then on your tables are a stack of 3x5 note cards. Those are for your use if you have specific questions you'd like to ask. At the end of the presentation, we'll pick those up, and Mr. Buckner will answer those questions for you. I would say don't make them too personal that you don't want to share them with the general public, but if they're of general nature, and we can use those. Also, if he will take questions throughout the presentation, but we don't want to have too many of those to slow us down so we can cover our entire content. He will also be here for a few minutes afterwards to answer any questions you may have. And also, we are recording this, and we will be sending to each of you a link. If you want to go back and reference the presentation for your future usage, that will be available. So please be aware of that. So you can sit and listen as much as you would like, as opposed to trying to furiously write everything down. With that, I'd like to have Tom Buckner come up, and I'll do a little introduction for him. He's our special guest and presenter today. Tom Buckner is a Vanderbilt law alum, and his wife is a Vanderbilt graduate. So we have a couple of Vanderbilt graduates from different sides of the campus here today. Tom's no stranger to Vanderbilt. He's been here numerous times. He received his law degree in '74. He's a member of the Memphis law firm Apperson Crump, and founded by your great-grandfather?
No. It's founded by Charles Crump, my recently deceased partner's grandfather, in 1865.
Wow.
After the Civil War.
Okay, so
In which he fought, not Charles Crump, his grandfather.
His grandfather fought. Okay, so he's a fellow of the American College of Trust and Estate Council, and has presented over 40 legal seminars and otherwise. His topic today is best practices in estate planning, and we welcome you to enjoy today's presentation. And please let us know if you have any questions at the end. To that, I'll turn over to Tom. Thank you, Tom.
Okay, thank you, Joe. Okay, my year of graduation from law school is 1972, not 1974. But other than that, there's nothing else I have to say about that. Okay, it's my pleasure to be here. Estate planning is something that a lot of people talk about, but not everyone actually does much about. Most people really die without a will, strangely enough. Sometimes it doesn't matter. We'll get into ways this morning that you can transfer property without a will. It's better practice to have a will, and we can get into that. On page 1, let's see, 6 things, just general practices of estate planning, of best practices. First, you got to determine the nature and value of your assets that you own or you control. Secondly, who do you want to receive those assets at your death? Third, are there any estate or gift tax, income tax consequences or planning that you should do to achieve the best result in your planning? And also very important to determine whether you want to leave the property to beneficiaries outright or in trust. And do you want to avoid the probate court process? A will goes through probate court. You may decide you don't want to go through probate court, and you can do that if you do the proper planning. And lastly, signing the documents, including beneficiary designation forms. In addition to a will or a trust, a lot of clients' assets now are in retirement plans, IRAs, or life insurance, which the will doesn't control unless you name your estate as beneficiary. There are income tax reasons not to name your estate as beneficiary of your IRA or retirement plans. Insurance doesn't matter, but retirement plans, you need to have an individual, and we'll get into that. So be sure you sign all the beneficiary designation forms and get copies of them from the administrator or life insurance company to make sure it's what you sent in. Often we've had clients who think the beneficiaries of their plans are A, B, and C, then they die, and it could be D, E, and F, or different percentages of A, B, and C. Or A dies, there's no contingent beneficiary who gets it if A is deceased. So it's important to get certified copies from the administrator of what is on their files, because it doesn't matter what you send them, it's what they record in their files. And they write the rules on all these plans, so you're going to have a hard time, your heirs, fighting with them. Okay. All right. Transfer of property by will. Okay. And this is just my estimate of how the probate process began. The law usually is designed by people who have money and who are creditors. And so the way I picture it happening was after somebody died, his or her spouse came to the bank and said, here's my spouse's will, I'm executor and sole beneficiary. I'm entitled to everything in his name or her name. So the person gets the money and runs off. The next day, a child comes into the decedent with another will, which may be a later will. It's only the last will that's signed by a competent person that controls the property in that person's name. So a court has to admit a will to probate and find that that is the last will and testament of the decedent. And that petition before the court is brought by the person who is named executor in the will. That's a legal title that means a person who is in charge of executing the provisions in the will, which involves notifying creditors, paying debts, paying taxes, and distributing the property to the beneficiaries under the will. Okay, a will has to be witnessed by 2 persons, the signing of the will, who aren't beneficiaries. In some states, it's 3 persons. It's 2 in Tennessee. And those persons originally had to testify in court after death saying, yes, Joe signed this will, I was there, he said this is his will, asked me to witness it. In Tennessee, since '71, the witnesses can sign an affidavit, either at the time the will is signed or later to avoid court appearance, unless there's a will contest. Okay, or if you have no witnesses to the will, it has to be entirely in your own handwriting. You do not need witnesses. And after death, then 2 witnesses to the handwriting of the decedent come in and say, yes, that is Joe's handwriting, I recognize it. So it's difficult to cover everything in a handwritten will. I've seen several instances of clients trying to do it, and invariably they leave something out. So we don't recommend that. Okay, a will governs everything in the decedent's name alone. We'll get into things that it doesn't govern. If you die without a will, you still have to go through probate court, your heirs, if you have property in your name alone. The court will appoint an administrator who has the same job as the executor. They each are called a personal representative. And personal means they take charge of the personal property, not the real property, not the real estate, personal property. Bank accounts, brokerage accounts, stocks, bonds, mutual funds, tangible property such desk, artwork, jewelry, take charge of that, give notice to creditors, and distribute the property to the intestate heirs. Now, let's see, on page 2 of your handout, you've got transfer of property of a decedent without a will. And this is Tennessee rules. They're pretty much the same in every state except for community property states, which we'll discuss here in a second. If there's a spouse but no children, the spouse inherits everything if you die without a will. If there's no spouse and children, the children divided equally. If there's a spouse and children, if there's one child, the child and spouse inherit 50-50. If there's one spouse and 2 or more children, the spouse in Tennessee gets a third, the children divide 2/3, whether it's 2 children or 4 children, whatever. And if there are no spouse or children, it goes back to the maternal and paternal and grandparents coming down. If they're parents, parents get it. No parents, siblings. No siblings, well, there's no children or grandchildren, of course. Then you go to the cousins of the person who's deceased, and it's sometimes hard to determine who the intestate heirs are, going back to the grandparents of the decedent. I had a case 2 years ago where a person died, no spouse, no children, and there were 18 intestate heirs. We finally found a 92-year-old woman in Tampa, Florida, who knew everybody. and she was related by marriage. She wasn't even a beneficiary. Oh yeah, so-and-so lives out there, and he died and had 2 children, and one of those died. And so the judge in Memphis was amazed. I got all 18 to sign something agreeing, yes, we agree, this is how it goes. So there wasn't much money, about $300,000, and none were in Tennessee, and I had to be appointed administrator by the court, because if there's no will, the court appoints, in order of next of kin, someone to administer the estate. Well, but that person has to live in the state where the decedent died, or where the decedent had his domicile. So if everyone's out of state, the court will appoint a local lawyer sometime or someone in that state to serve as sole administrator or co-administrator with a cousin or someone who's out of state. In this case, no one wanted to serve with me because they have to fly to Memphis from Oregon and other places. So it's better to have a will. You can avoid all these problems with the will. Name one person or 2 persons as executors and name the beneficiaries. Okay. We discussed the probate court process. Okay, we should point out, let's see, that you can't disinherit a spouse in Tennessee, in many states, unless you have a valid prenuptial agreement, where before marriage, the 2 fiancés agree on death or divorce, I get this, you get this, and so forth. If that's signed before the marriage, then each spouse can waive rights to inherit from the other spouse. In the absence of that, in Tennessee, and other states are similar, the day of marriage, each spouse is entitled to at least 10% of the other spouse's estate, or whatever the will leaves them. So if the will leaves $100,000 to, say, the husband, okay, and then the wife dies, the husband can take either $100,000 or 10% of the wife's estate, whatever it is. And that goes up to 20%, 30%, and 40% after 9 years of marriage, unless there's a prenuptial agreement. Now in Tennessee and some states, in Tennessee since the 90s, you can have a valid postnuptial agreement. The old common law, the consideration for the agreement was getting married. If we marry, then here's the deal. So, but by statute, they've said if there's real consideration that flows, if one spouse says, I'll give you $100,000, write the check now, if you sign this form saying that you don't want anything when I die, you get nothing. If each spouse has independent counsel and know what they're doing, then that's valid. But in the absence of a postnuptial or prenuptial agreement, you can't disinherit a spouse. Okay. Okay, let's talk about passing property without going through the probate court process. Oh, I should mention another reason behind the probate court process is to protect the creditors. If someone dies and owes the bank money, the bank wants to have notice of the death. If there's no probate court proceeding, they may not get notice, and the heirs could run off with the money. So if there's a probate court proceeding, the executor administrator has to give notice to all creditors. And in Tennessee, they've got 4 months to file claims. The estate can't be closed, and the property can't be distributed to the beneficiaries until all creditors are satisfied. If the executor disagrees with the creditor's claim, you can file a contest. The judge will decide, is it valid or not? So that's another reason why the court gets involved when people die. Okay, now you can avoid probate, fairly easily by having joint property. Property that's owned jointly, the will doesn't control that. Husband and wife have a joint bank account, a joint brokerage account, a joint residence titled in both names. One dies, it all goes to the survivor, regardless of what the will says. Now, if there's a big mortgage on the residence, the will should address who's going to pay the mortgage, because the estate of the decedent is liable for the debt of the decedent. If husband dies first, and there's a jointly owned residence with a big mortgage, and the wife gets a residence, but she's got this debt to pay, the will can say that his estate, the husband's estate, can pay the debt, or it can say that the wife inherits a property subject to the debt. Depends on the situation. There's no right or wrong answer. It's just something that people need to be aware of. The debts are going to be paid by the estate unless the will says otherwise. That's a general rule. Of course, the will could say any secured indebtedness is assumed by the beneficiary inheriting the property, and that answers the question. But not all wills say that. Okay, joint bank accounts. There are often disputes about, is a joint account really a joint account? And you say, well, there's two names on it, that's a joint account. Well, not necessarily. There's something called a signatory account, which clients frequently name someone, a child typically, to sign checks because he or she doesn't want to be bothered with signing the checks. Oh yeah, a child can sign checks. Okay. Well, if that's a joint account, when the parent dies, it goes 100% to the child. There could be 4 children, but it's a joint account just because the parent wanted the child to sign checks. Well, it should have been a signatory account, meaning the child can sign checks, but on the death of the parent, the account goes under the parent's will to all 4 children equally, or whatever your parent wants to say. So that is, we see that a lot. The banks have gotten the statutes passed to protect themselves, as they usually do, and making joint accounts, some accounts are questionable. There's a tendency to say they're really joint accounts to avoid fighting with the executor of the estate over, was it a signatory account or a joint account? But you need to get a copy of the bank paperwork and see what it says. It'll say joint account or signatory only account. Okay, next on page 4 of your handout is a lot of material on revocable, or living trusts. Lawyers call them revocable trusts because they can be revoked by the grantor, the person who sets the trust up. It's called grantor, settlor, or contributor, different words. Let's just say grantor. The person who puts his or her property in a trust names himself, herself as trustee. Okay? And on the death of the grantor trustee, the trust sets forth who the successor trustee is and who the beneficiaries are, just like a will. And you say, well, why doesn't a grantor trust, a living trust, have to go through probate like a will? Well, The reason is a will, there's only one person signs the will, if you forget the witnesses. The testator, or testatrix, if female, signs the will. It's an ex parte document. A trust has two parties who sign, the grantor and the trustee. So the law developed, well, grantor and trustee, the court needn't get involved because both of them read it and, there's some negotiation. And so there's no probating of a revocable living trust to be authentic. Even if the grantor and the trustee are the same person, which they frequently are. So there's no two separate parties, it's one person wearing two hats. Still, that avoids a probate process. And when you think about persons who own real property, especially in several states, you have to go through probate in several states if the property is just in your name. You got probate in Tennessee, Florida, wherever. So, but with a living revocable trust, you could be trustee, you got to deed the property to yourself as trustee. You could have property in 10 states. There's no probating at all. So that's an advantage of a trust if you have property in several states. You got to keep in mind that you have to transfer the property on the records of the financial institution or record a deed if it's real property to have it effective. You can list in a schedule to the revocable trust, all of my property, A, B, C, whatever, I give to the trustee. Unless you have the bank change its records from Joe Smith alone to Joe Smith, trustee of the Joe Smith Living Trust, you go through probate. And clients frequently don't follow through and get stuff done. Or if they do, then they acquire something else and don't put it in their name as trustee. The biggest problem clients have with the living trust is they don't want to have the trouble of transferring all their property to themselves as trustee. Really, you go through probate while you're alive with the living trust. If you die with property in your name, the executor or administrator transfers it to his or her name, then goes to the beneficiaries. With the living trust, you transfer property while you're alive to your name as trustee. Then after your death, the successor trustee steps in, as named in the trust document, and transfers it to the beneficiaries. Well, it's easier to go through probate while you're alive because you're there, you know what you own, rather than having someone else go through it after you're deceased. You may have all your records laid out like this nice form that Vanderbilt prepared, which I highly recommend, filling out this material. But people don't always do this, and they don't update it, which is a problem. So, the living trust, the only disadvantage is you got your name as trustee. Now, banks now don't require that trustee be on the check. Joe Smith, trustee, they can just say Joe Smith. On their records, it's really owned by Joe Smith Trust. Different banks and different rules on this. So that's the biggest negative. People don't like the looks of things. Well, if you want to avoid probate and save some legal fees after death for your heirs, the living trust is a good idea. It's not for everybody, and I'd say the idea started in California back in the 70s, and in Tennessee there were very few living trusts, at least I'm aware of, back then, but nowadays I'd say probably half of clients with some property have a living trust. Well, maybe 40% have a living trust, 60% just have a will. Even if you have a living trust, you need to have a will as a backup to dispose of property that doesn't get transferred to the trust, which frequently happens. You die, you have a stock certificate stuck off in the desk, and the spouse didn't know about it. Okay, it's in the decedent's name. Or I had a client who had a lot of assets. We got it all transferred to the trust, except he had a corporate bond we couldn't get transferred because it was in default. So what can you do? So the client can't do anything. So then he dies, the client. Then the bond gets out of default. It's worth some money, like $25,000. So off to probate court we go, get the executor appointed to pour it over to his living trust. So the will is a very short will. You name executor. The sole beneficiary is the living trust. So anything that doesn't get in the trust while you're alive, after you're dead, ends up in the trust with the same beneficiaries. Or the grantor of the trust could inherit property. So the grantor's alive, the grantor's cousin dies, and leaves the grantor as the named beneficiary in his or her will. Okay, but before the property is distributed, the grantor of the trust dies. So the executor of the cousin's estate has to write the check to the grantor. Well, he's deceased. So off you go to probate court to get the inheritance. See, things like that happen. I mean, it sounds far-fetched, but I've seen them happen. So you have a pour-over will to make sure everything ends up and goes to the same right beneficiaries. Okay. Page 7, Article C, paragraph C. Property passing by beneficiary designation. This is probably the area where we have, not trouble, but we can render the most assistance to people, making sure they have the right beneficiaries on their IRAs and retirement plans and life insurance. As I said earlier, unless you have the estate as beneficiary, the will doesn't control anything about the IRA, retirement plan, life insurance. The administrator, insurance companies, beneficiary list is going to be governing. So with IRAs and retirement plans, you've got income tax consequences. Whether the participant draws the money out while he or she is alive, or the beneficiary after the death of the participant draws it out, there's income tax to pay. The planning objective is to stretch out the payout as long as you can. The participant has to begin drawing the money out of the IRA retirement plan at age 70 and a half, actually April 1st of the year following the year in which he or she obtained 70 and a half. So if the beneficiary dies, or if the participant dies, the named beneficiaries have to draw it out either over the deceased participant's lifetime or their lifetime, depends on whether the participant has started to draw it out. All the details are in your outline here, pages 7, 8, 9. This is more detail than you may want to read now, but it's important because it's a technical area. And keep in mind that you can't name a non-spouse as beneficiary, primary beneficiary of a retirement plan without the spouse's consent. Now that doesn't apply to IRAs in general, but if you got a retirement plan, you have to name the spouse first. Then you should name others as contingent if the spouse doesn't survive. With these beneficiary designations, the rules that all the administrators just about have is if you name only one beneficiary, one primary beneficiary, and you don't name any contingent beneficiaries, if the primary beneficiary doesn't survive the participant, it goes to the participant's estate, which is a bad result because the stretch out rules say if you have a non-beneficiary, you've got a 5-year payout, which means if you got $1 million, say, in the account, you got to pay it out over 5 years. Pay it out all in the 5th year if you wanted to. That's all income, whoever gets it. Now, they've loosened up the rules on this a little bit, some administrators. Some administrators say if the estate is a beneficiary, then they can roll it over to a new account in the name of the estate. Then the executor can name the ultimate beneficiaries under the will or trust as the beneficiaries, then they can stretch it out. Now, Fidelity does that, Vanguard does that. A TIA-CREF will not do it. I've been through all this recently. But you can transfer it, say, from TIA-CREF to Fidelity, go through paperwork, and you can get the right result, we hope. It's not done yet. So all this could be avoided if you consult with someone when you name these beneficiaries. And the TIA-CREF fellow in Memphis, he changed the investments. I didn't know about it. Then the client dies. And I said, did you change the beneficiaries? Oh, no. We had the right beneficiaries from last year. Find out after about 2 weeks, he changed the beneficiaries to the estate. He wrote in the estate. So we're stuck. But we can move it from TIA-CREF to Fidelity and get it straightened out. There's a lot of money tied up in these retirement plans and IRAs. They need to be carefully looked at by someone other than the sales rep for the company. That's my advice. Okay. Oh, I forgot to point out some typos. Let me correct these. Okay, let's go back. Okay, this is my fault, not Vanderbilt's. Okay, on page 5, let's see. 1, 2. The third full paragraph, it starts with the trustee may continue. If you go down to the 5th line, the first word is courses with an S. Delete the S. The sentence reads, of course, comma, a trustee. So that's one typo. Okay. On page 7, the second typo is under paragraph C. We're talking about now 1, 2, 3, 4. The 5th paragraph, the usual planning objection is how it starts out. It should be objective. Okay. And the last, I hope that I know of, typos on page 31. Okay, in the middle of the page, generation skipping, transfer, tax planning. If you look down the 5th line, ration is known as the application fraction. It should be applicable, not application, as the applicable fraction. And there's another right before that. It says this ration, it should be this proration. Okay, excuse me. Okay, on page 31, it says generation skipping, transfer, tax planning. That's bold in the middle of the page. The first paragraph under that, the 1, 2, 3, the 5th line should be proration instead of ration, and after that is known as the applicable, not application, fraction. Okay, the problem with computer word processing is they can catch misspellings, but if they don't catch something, it's the wrong word, which you know that. So you got to read it very carefully. Okay. Back to the beneficiary designations. I think, let's see, we've covered that in some detail. You need to always name contingent beneficiaries. Oh, certain trusts qualify for the stretch out. I said earlier that you have to have individual beneficiaries to stretch out the payouts. Certain trusts called conduit trusts qualify. So you can have, say you have a child who's 16 or 18 or 40, doesn't matter. You can have a trust for that child as the beneficiary if the trust has language in there that says the minimum required distribution, MRD, must be paid out, and if the trustee withdraws any additional amounts, they have to be paid out to the beneficiary. So oftentimes trusts are preferred to having individuals. If they're minors, of course you have to almost. Even if they're not minors, trusts are a good idea. We can get into that shortly. Okay. Page 10, Small Estates Acts. This is just for lawyers, which hopefully no lawyers here, or excuse me, I hope there are lawyers here. This presentation is not aimed at lawyers, which I usually speak to lawyers, I'll confess, but this, in some states and counties don't require lawyers to help if the estate is under a certain size, even if there's no will, or if there is a will, you can avoid probate. In Tennessee, it's $50,000. So you've got some pitfalls even in Tennessee. The affiant, he goes down to court with the will, if there is one, or if there's not a will, with intestate heirs, signs and has to be liable to creditors to the extent of any assets in the decedent's name. So the affiant has some responsibility where he or she doesn't run off with the money and the creditors don't get paid. But don't spend any time on that. Okay. E on page 12. Okay, transfer on death, payable on death accounts. For many years now, banks have let customers open up a bank account and put payable on death to X because people want to avoid probate, which is fine. And so the banks let them do that. the last 10 or 15 years, even brokerage firms, Merrill Lynch, you can have a transfer on death, a TOD, payable on death is POD account, where Joe opens, you could have $2 million in a Merrill Lynch account and says on my death, payable to spouse or to whomever, put the name on there. Okay, that avoids probate. Problems are, most places won't let you have two POD beneficiaries for one account. You can divide the account in two accounts and have a different one on each one. And they won't let you put trusts as POD, TOD beneficiaries. It's too much paperwork. They don't have to look at the trust agreement or the will or whatever. So that really limits their effectiveness as estate planning tools, where you got to have one name and no trust. But that's fairly common now to have POD, TOD accounts. Okay, the next two items are minor importance. If you have motor vehicles and the name of the decedent, the spouse or children can have those transferred to their own name or some strange purchaser that they agree to without going through probate. I'm not sure, other states may not be as liberal as Tennessee. If you're doing a living trust, do not change the title of your vehicle to your name as trustee. Insurance companies don't like that, or the liability insurance companies, because if you've got Joe Smith as owner, yeah, Joe's going to drive it, probably, and that's fine. If you've got Joe Smith Trust as owner, they don't know, or Joe Smith Trustee as owner, they don't know who's in the trust. They may think that all the beneficiaries are going to be driving the car. They may raise your liability insurance rates. So don't put the vehicle title and your name as trustee. And don't put your spouse's name on the title either. This is unrelated to trust, but in Tennessee and most states, the owner of the vehicle, or owners, there's two, are liable for any negligence of the driver, whether it's one of the two owners or a child or someone else. So if you put both spouses' name on the title and there's an accident and the driver hits a school bus and you get sued for $50 million, you don't want both spouses liable if you got $1 million liability insurance. So that's not estate planning. Well, I guess it is estate planning to try to preserve your estate. So that's something that no need to worry about title to the motor vehicles. They should be titled in the name of the person who's going to drive the vehicle. If a child is driving the vehicle and the child is 18, it should be in the child's name, not the parent's name, and certainly not both parents' names. Okay, bank accounts, G, on page 12. In Tennessee, this has been 10 or 15 years ago, banks had the law changed where if there's $10,000 or less in the bank account, the bank can pay it out to a spouse or child without going through probate. This is no payable on death. It's no small estate act account, just any bank account, $10,000 or less, with proof of death, a death certificate, and banks vary. If the bank knows you, fine. If you don't, then you want some proof that you're the spouse or child of the decedent. So that avoids probate. Okay, let's talk briefly here, if you like, about trusts. I guess when I started practicing law in 1972, first, well, the estate tax exemption was $60,000, not $5,450,000. That's one big change. But people who had money would usually say, spouse doesn't survive, to my child or children if they're age 21 or age 25 maybe. If they're older than 25, the client didn't want it tied up in a trust. That was, 30, 40 years ago. Now things have changed a lot. As clients' children get older and as they marry, sometimes the clients have concerns about the spouses of the children. Sometimes they want to be sure that the money is left that they leave to the child is left to the child's children, their grandchildren. So they don't want it all going to a child or children equally, when if there's a divorce or death, you can't disinherit a spouse, so the money could end up in the hands, some of it at least, of the children's spouses and not the grandchildren. Or if the child hits a school bus and has a $50 million lawsuit against the child, If you've left property to the child, the creditor can get it if the child's negligent. If it's in a trust for the child, the creditor can't get it, even if the child is trustee. So the trend now is for clients to keep children's property in trust longer, sometimes for the life of the child. And you might say if the child is 35 or 40, the child can be trustee. And you give the child the right to appoint a successor trustee. The child is trustee appointer. So if the child hits a school bus and sees a lawsuit coming, then the child can appoint, a sibling or someone else as trustee, so the child can't control anything. The creditor can't make the child make a distribution to himself, herself, which the creditor could attach. So that's one development over the years that we've seen where people really aren't worried about trust, and the child can be trustee. So you've got the advantages of the child controlling things if you want the child to, or the child, you could say the child can appoint a corporate trustee, or the child can pick someone else, a corporation, to serve as trustee for investment purposes if you think the child might not be able to invest the property himself, herself. A trustee has two duties. One, invest the trust property. Two, make distributions according to what's set out in the will or trust. And you can have directed trust where the trustee has the right to direct the investments be handled by a third party. You could give the trustee discretion on who the third party is, or let them, or you could specify a group maybe they had to pick. There's different ways to handle these things. Okay, as I mentioned earlier, the estate tax exemption now is less a concern for many people because it's $5,450,000 for persons who die this year. The way the law is written, it goes up by inflation every year. Inflation hadn't been much lately, but it goes up. Of course, they can change the law, as we know. The law could be changed, depends on who's elected president, and may change. Like Will Rogers said, no one's safe while Congress is in session. If Will were alive now, he would add, or if there's a president who signs the executive orders, and without Congress having a say-so, which that's happened. The administration now has these proposed regulations under Section 2704, which you may not be familiar with. It has to do with restrictions on family businesses in general to eliminate or reduce discounts on valuation. And it's, anyway, that's a whole other topic. But so there's a lot of details in some of these things, a lot of ways you can save estate taxes by doing things that we won't get into today, except charitable techniques we can use. I'll touch on that. It's a very technical area. Okay, one good thing, or a second good thing besides the exemptions being increased is we now have portability of the estate tax exemption. Okay, if there's a surviving spouse, the surviving spouse can add to his or her exemption whatever the first deceased spouse didn't use. Say the first spouse, say the husband dies and had $2 million, okay. Suppose he left that all to the surviving spouse. He didn't use any of his exemption. If he left $2 million to a trust for the children, he's used $2 million of it, but he had $5,450,000 if he dies this year. Say he left $2 million to children. Okay, he's got $3,450,000 that the spouse can add to her exemption when she dies. Unless she remarries someone who dies before she does, and the second husband, has a large estate and uses all of his. So you can't serially add the unused exemptions. I think this might be somewhat humorous in here somewhere. There's some statement about that you can't serially marry and accumulate all the exemptions. So it's the last spouse that you're married to dies. Here's her exemption you can use. But that is a big plus because the old days, lawyers said, okay, married couple, divide your property 50-50 because we don't know who's going to die first. Say the husband had $1 million, you'd say put $500,000 each spouse's name because if the wife dies first with nothing, you've wasted her exemption, which didn't make any sense. It increased the tax to the children after both were dead. Now with the portability, that's not necessary anymore. You can have everything in one spouse's name if you want to. Now, as I point out here, the generation skipping, that's a whole other topic, tax is not portable. So it's, you can skip a generation, $5,450,000 can go to grandchildren, but that's all. If the husband, say, doesn't leave $5,450,000 to grandchildren, then the wife who dies secondly can't add his unused GST exemption to her GST exemption. But that probably is beyond the scope of what we're getting into today about generation skipping. Okay, charitable planning, I want to mention one thing. There's a lot of material here on charitable planning. I want to say a couple of things. Consider naming a charity as IRA beneficiary if you're going to have children or family members under the will as beneficiaries, because the amounts received under the will are income tax free, no matter how much it is. You can have $100 million, inherit that income tax free. If it's an IRA, that's not income tax free, but if it's non-IRA type assets, but whoever gets the IRA money out over time is going to have to pay income tax on it, except charities. They're tax exempt. So if you have Vanderbilt in your will, it's $10,000, $100,000 hopefully, then you can change that and leave your children as the beneficiaries or spouse, and then add Vanderbilt as an IRA, say, beneficiary. It'll save income tax because your children, whatever comes out of the IRA, they only get the after-tax benefit. Tax rates, what, 39.6% plus 3.4 if they're in the top bracket. So you can save money, and you can change the IRA beneficiary just like the will anytime you want. There's information here about lead annuity trust, which just very briefly, in valuing split interest trusts where charity has an interest, then family, the IRS has a section 75/20 rate, what they assume you will earn each year. It's 1.4%. Well, actually it's 1.6% in October, 1.4% in September. So if your trustee can beat 1.4%, the excess over that passes to your children, whomever, estate tax, gift tax free. So it's not hard to beat that if you have enough time. Depends on the Federal Reserve, what happens in the investment world. I'm no expert on that, but you've got a good fighting chance. If you're going to leave money to Vanderbilt, a CLAT, Charitable Lead Annuity Trust, LAT, would be something to look at. I think I may be talked too long here. I'm not sure. Joe, what, am I out of time? Or I got 2 minutes. Okay. All right. On the charitable front, just a couple of fairly simple things about savings bonds. This is on page 33. If you have savings bonds, you have named beneficiaries perhaps, then they're going to pay income tax on the accrued interest income, more than what you paid for the bonds. Okay, if you give those to charity, there's no income tax to the charity. But you have to specify in your will, I think this is written out here, that you leave H bonds, double E bond to, say, to Vanderbilt. If you say, I leave $10,000 to Vanderbilt, and the executor funds those with the H bonds, the state pays income tax on the income appreciation. So that's a drafting point. There, let's say. Okay, conservatorships, there's a lot of detailed information here about conservatorships, and that's something, a living trust, in addition to avoiding probate at death, at lifetime, you can specify in your living trust who determines incapacity. We've seen several in Memphis family fights over conservatorships about parents, children fighting, and it's not pleasant. Well, it can be avoided if the parents in a living trust specify a committee to determine when father or mother is incapacitated. It can be the children, you can have a doctor by unanimous agreement. Okay, then you name who the successor trustees are to take over if there is incapacity. And avoid a conservatorship where a judge decides is there incapacity and who's going to be the conservator for the incapacitated person. You can set out all this in a living trust in some detail. And that's a good reason to have a living trust, is to avoid the conservatorship fight that's a public fight while you're alive. Okay? Any questions or? Yes, sir.
It seemed to me that with the group from around the country, you might want to comment on Tennessee's beneficiary laws on reducing income tax and capital gains tax, community
Right.
property trusts, and other type vehicles.
Okay, well, first on Tennessee, the income tax in Tennessee is scheduled. There's an income tax on dividends and certain bond interest. Non-government bond interest, excuse me, basically. It's 5% this year, and it reduces every year by 1%. It's gone, I think, January 1, 22, I think is when it's eliminated. The community property rules that trust that Howard spoke of, that is something that puts Tennessee in an equivalent position with community property estates, which are listed here in one of these pages about community property. And it gives creditor protection to surviving spouses if the trust is structured properly. This is a very general statement of it. So it's something that you ought to look at if you have any creditor concerns. And I should mention in Tennessee, then the Tennessee Investment Services Act of 2007. The rule generally is you can't put your own property in your own trust and be beneficiary and protect that from creditors. In 2007, Tennessee legislature passed a law saying you could do that. They called it the Investment Services Act Trust so as not to attract attention from the bank creditors. It worked. So you can protect yourself from future creditors. You can't be your own trustee. It's irrevocable. You can't be trustee. You can live in another state. You have to have some property in Tennessee. And there's probably 6 or 8 states across the country now that have something like this. So you can protect, you shouldn't put all your property in the TIS, they call it. You can put a big chunk of it. Doctors like this, because they could be sued for malpractice. They can put stuff in a TIS trust, and they can be beneficiary. They can't be trustee. And so the creditors can't get at, future creditors can't get at that, which is a great creditor protection planning tool. On the inheritance tax front, Tennessee inheritance tax is gone now. I list the states. There are a few states still have an inheritance tax. One thing with trusts, California is bad in a lot of areas on taxation, but if you have a co-trustee, say you live in Tennessee and you die, and you've got a California co-trustee, all your beneficiaries in Tennessee, California will subject the trust income, if they know about it, to California tax because you've got one trustees in California, which doesn't make any sense. So you got to look at state income taxation of these trusts. Very high in California, New York. You need to always give the trustee the right to change the situs of the trust. And the trust agreement give the trustee the power to change the situs to South Dakota, Tennessee, Alaska, Delaware. I'd say Tennessee in almost all rankings, one of the top 4 or 5 states in the country for creditor protection, state income tax, rule against perpetuities, and other things. So states are important. You don't have to use the law of the state in which you're in. That's the point to remember. Okay. Anything else, Howard? Okay. Okay. We have some other questions here. Okay. On page 13, you say that lifetime gifts are preferred over transfers at death. Can you explain? Okay. Okay. Well, the exemption of $5,450,000 is a lifetime exemption. You can use it all while you're alive or wait till you die. If you give, say, $3 million away now and you live for 10 years, all the appreciation on the $3 million is out of your estate. So your exemption is reduced by $3 million. When you die, you have $2,450,000 if you die this year, but all the appreciation is gone. So you're better off giving things, even if you pay gift tax, a gift tax reduces your estate. So say you give $7 million away, okay? $5,450,000 is exempt, no gift tax. You've got $1,550,000 you pay gift tax on. Okay, so you write a check for 40% of that, 600 grand, whatever it is. But that 600 grand is out of your estate. When you die, you don't have 7 million, plus you don't have the 60 or 600 grand you paid tax. When you die, the estate tax is tax inclusive. The assets you leave to your children are taxed. And so the state writes a check for the tax. So the children get less. The children bear the brunt of the tax. On a gift tax, it comes out, so the state tax is less because the gift tax is gone. Does that answer the question? Whoever answered this, asked this, okay. Okay, what is considered a charity in an IRA designation? Are all foundations and churches considered charity? Yes, it's a 501c3. Churches are charities. You need to check with the charity and make sure they're a charitable organization. It's section 2055, there's a bunch of, and 170, there's a bunch of Internal Revenue Code sections they have to fall within, but in general, there's all sorts of rules about private foundations. If one person contributes all the assets to a private foundation, you have different tax rules. So that's beyond the scope here to discuss, but you can have a public foundation, a publicly supported foundation, and that's, fine. Okay. We have a joint revocable living trust. We have been told for traditional and Roth IRAs, 401ks, 403b, etc., we should name our joint. No, you shouldn't name that. You should name the spouse first, and then name children, if they're adults, and if you trust them to handle the money, or if not, name separate conduit trusts for each child as contingent beneficiaries. That's just a general answer, okay? Yeah, now life insurance doesn't matter. You can name, because there's no income tax on life insurance death proceeds, absent transfer of value, which is a technical point. But so yeah, you can name the spouse or children. You have the same considerations. If you name the spouse, do you want the spouse to be able to name his or her second husband or wife as beneficiary after you're dead, or you want it to go to your children? If you do, you should name a trust. The spouse could be beneficiary, but at her death or marriage or something, it goes to somebody else, say the children. So you've got non-tax factors on the beneficiaries of the life insurance. The IRAs, 401ks, that's an income tax factor that if you're stuck with the joint revocable living trust, you may be able to finesse your way through that, but it's not worth taking a chance on having the 5-year payout apply to that. Okay? Is there a dispute within the legal profession as to what should be in a trust versus a will? Every lawyer has a different opinion. I don't have a living trust myself. People ask me, what do you have? Maybe I will have one, I think, eventually. I would say there's more reason to have a living trust probably in a lot of cases than there is just to have a will. Even with the living trust, you should have a pour-over will in case something doesn't get transferred to the trust, as we discussed. So,
Can I continue? I asked that question.
okay, yes.
My lawyer recommended certain things to be in the trust and other things to be in the will. Friend that lives in the same community has a different lawyer, and he recommended different things.
What things were they that one said?
I don't have
Okay.
that data with me.
Okay. Well,
It might be the out-of-state property that you mentioned earlier, should be in the revocable trust.
yeah, if you have real property, real estate in several states, it should be titled in the trust.
I don't know that that was the
Okay. If you have brokerage accounts, bank accounts, it really doesn't matter. In the old days in Tennessee, the lawyers' fees, executors' fees, were based on a percentage of what's in the estate, the personal property. The fees often were too high for the work the lawyer did. So on a $1 million estate, there's a 3% rule, sort of, that's $30,000 lawyer's fee. Well, that's too much unless there's some strange problem. Nowadays, the probate judges tend to look more at the hours the lawyer spends, at least in Memphis and Nashville. In other counties, I'm not sure. So you avoid any court setting of fees if you have a living trust. That's one reason to have a living trust.
Well, like I know, one of the things that was recommended, don't put your automobile in the.
That's right, because the liability reasons I mentioned, and the liability insurance premiums could be higher if the trust is the owner. Yeah, that's for sure. That should not be in the trust, for sure.
You have a list of things to put in the trust and put in the will. I discussed it with a friend, and they said, well, my lawyer disagreed on certain items.
Yeah. Lawyers disagree often on things. Yeah, that's all. In every lawsuit, they disagree. Okay. Other questions we have?
Yeah, I have a question.
Sure.
So if you have stocks and bonds and you move them into a trust, do they get any cost basis you have to take, is it like you sell it and you take the capital gain and you move it from your personal account to a trust?
Okay, that's a good question. No, a transfer while you're alive to your living trust is considered, the trust is the same taxpayer as you, if you're a trustee. You have the same tax basis, whether it's in your name or your name is trustee. It's a grantor trust under section 671 through 678 Revenue Code, so all the income of the trust is reported on your tax return. The trust needn't file a Form 1041, that's the trust income tax return. If you have the grantor, if someone else is trustee, then it may be a separate tax return filing. It still should be reported on your 1040, as long as you're alive, okay? Now, death, I didn't touch on the step up in basis, it's in the outline here. One important thing, whether it's in the living trust or in your name alone, at your death, your heirs have a step up in income tax basis to the value at your death, which saves a lot of income tax when the estate or your beneficiaries sell the asset later, whether it's stocks, bonds, real estate, doesn't matter. So that is, now you have to, there's a new IRS form out, which I mentioned here, Form 8971, you have to file it where the IRS can keep up with the benefit, with the basis, the value on the death of the decedent. It pretty much applies to anyone who has to file an estate tax return, Form 706, plus even if there's no tax due, you still got to file this basis form, 8971. They just came out with it this year, actually June, I think. So the step up in basis, which applies to all assets except IRAs and retirement plans. It doesn't apply to income in respect of decedent, IRD, that's a legal term. So, but everything else is stepped up.
If it's a joint trust, is it the death of the second one, second person?
Depends on how the joint trust is written. If the joint trust is written where husband puts in, $1 million, his property, and wife puts in $2 million of her property, okay? Then when the husband dies, if that property stays separate property and he can draw it out without the wife's consent, then there's a step up in basis on his $1 million. If, however, he puts it in the trust says all property contributed is owned 50% by each spouse, then you have a 50% step up on half the property, you see. So the wording of the trust can govern the step up. Depends on who controls it at the moment of death and how much the deceased spouse controls. That's a lawyer answer. But it's a good question. And we see these trusts that are written, a lot of,
Well, most people that write revocable trust,
yeah,
husband and wife, one of them's going to die before the other one.
right.
They're not going to die at the same time.
Right. I prefer to have separate revocable trusts, like you have separate wills. I've done joint trust if they insist. Depends on the client. It's easier to understand if you have a husband's trust, wife's trust. She controls her. Yeah, if you got a joint trust, or you can have 3 trusts. A joint trust for some property that you want each to have to agree on everything, but you want some property, you want the husband alone controls it, And see, it depends on the situation.
My lawyer didn't say anything at all about it.
Okay, well, it depends on the clients and the situation. Anyway,
Thank you all for attending today. We really appreciate it. And Tom, thank you for your presentation.
my pleasure. Thank you.